Good morning to everybody. Thanks very much for joining us this morning. So today we're going to look at some of the issues arising out of protected beliefs in the workplace, focusing largely on how you establish whether there is actually protection in relation to an employee's or workers' belief. Just by way of background, you may recall that obviously the Equalities Act 2010 implemented the religion and belief aspects of the equal treatment framework, which we hold on to notwithstanding Brexit, on the basis that we now have some retained European law. And the framework, rather like lots of other parts of discrimination legislation, prohibits direct and indirect discrimination and harassment in the workplace in respect of religion, religious belief and philosophical belief. And it also protects those from victimization if they're asserting issues in connection with this. So just moving on to the next slide, to give you a brief overview of this morning's session. We're going to look at what is a protected belief. I'm going to look at the extent to which minority beliefs can be protected, look at some of the recent case law, and in light of that, how you might look about, as an employer, balancing competing beliefs in the workplace and practice. And then, as you normally do, Alice and I are both open to hopefully answering questions that you may have that would have been triggered by what we've been talking about this morning. So just to kick things off, we've just got a very short poll, which we'd appreciate if you could answer yes or no to. And the question is, can gender critical beliefs qualify for protection under the Equality Acts of the framework I just mentioned? And when we're talking about gender critical beliefs, we're talking about a belief that a person's sex is immutable and a biological fact and can't be conflated with their gender identity, and that a trans woman who identifies as female, if you hold these beliefs, is in fact a man, cannot be a woman. So something that's quite controversial in workplaces and also in society generally. Do you think that that type of belief can get protection under the Equality Act? If you'd like just to do the poll of answering yes or no, and we'll just take a straw poll of what people think. Okay, so 77% of you think that potentially yes, there is protection, and 23% of you think that there isn't protection available. So in short, there is a level of protection, and really what the seminar is going to look at this morning webinar is to actually go through some of the detail in relation to how protection may arise. It may not arise in all circumstances, but there are cases now that point towards a certain level of protection. So if we just close the poll and move on to the next slide. Starting with, I'm going to just cover some of the background and the framework, and then Alice is going to do a review of the case law and the horizon scanning that I mentioned. So what is a protected belief? So under the Equality Act, it essentially says that religion, in relation to religion belief, any religion can qualify for protection. And you should also bear in mind that if someone has a lack of religion or doesn't believe in what others believe in the workplace, they have an equal amount of protection. And religion is by necessity really quite a broad definition, and essentially embraces the Article 9 right of freedom of thought, conscience and religion. The main requirement is that a religion has a clear structure and belief system that you can articulate and identify in relation to someone asserting that they're following a certain set of principles. In similar ways, there's also then a belief as well as religion, and it can include a philosophical belief. Again, someone who doesn't subscribe to that belief gets protection as well. The EAT in case law has been clear to say that there's no special protection applied to one category of belief over another. All beliefs are to be equally treated. You can see where this may start to cause some issues in the workplace. And the EHRC guidance that's been issued in relation to religion and belief essentially says that employers should only question a belief in the most exceptional circumstances. That's where, for example, it's maybe very obscure, appears to be objectively unreasonable, or the sincerity of the belief of an employee is genuinely in doubt. So that's largely going to be a question of fact based on the issues that are in front of you, or the evidence that you maybe acquire in an investigation. So there's a very broad structure therefore in place by the Equality Act as to potentially where protection may arise. And then in relation to looking at philosophical belief in a bit more detail, there has been some various approaches in case law as to how an employer would just go through to rationalise whether there is a belief that potentially has protection, and then look at the discrimination framework on the back of having gone through that process. So in terms of therefore what is a protected belief, if we just go to the next slide, you'll see a reference there to the Granger Criteria. And that is a reference to the case of Granger and Nicholson, which some of you may remember. It was a case reported back in 2010 now, so it's a few years old, but it's still good law. And that case related to Mr. Granger, who had a philosophical belief relating to climate change. And it was one of the first cases that really tested whether someone could how you went about establishing a belief. And in that case, the criteria were reviewed, and it was found a certain number of principles were established as to what employers should take into account when taking into account somebody who says, an employee who says they have a certain belief system and therefore they have a problem with instruction or a workplace condition or with colleagues. And an employer just essentially needs to work through this list. So you first look at whether the belief is genuinely held, which is going to be a matter of what the employee is telling you, and maybe some anecdotal evidence or other understanding if they've always held those views, whether there are an understanding of how they live their life, if it potentially informs other principles outside of the workplace. Secondly, the belief has to be a belief and not an opinion or a viewpoint on a present state of information available. So again, just understanding by inquiry that isn't just someone holding an opinion on something that they've adopted for the purposes of the arguments, and that actually there is a belief system that underpins what they say. It is important when you're looking at this, it's not for you or the tribunal ultimately to assess the validity of the beliefs, but it's to basically just make inquiry as to whether someone has that belief system and whether they have adopted a set of principles or beliefs in terms of how they choose to live their life or make decisions in their life. You then need to look at whether that belief is essentially weighty and substantial aspect of human life and behaviour. So does it go to something significant in life? And whether it has a level of cogency and seriousness and cohesion and importance. And this is where you bring the strands together, and you just need to assess whether there's a logic to it essentially, or essentially a level of cogency around it. Now, obviously, quite a few people's beliefs to somebody else may be illogical, or there may be science that disproves it, and it's really not to challenge the belief on that basis, but it's to understand the basis of which that employee is asserting that they have their belief and that they have a cogent set of principles around it. They take it seriously. There's some cohesion, and they place importance on it, both either in the workplace but also in their life more widely. And then the final part of the test is then to review the extent to which, when you've looked at those principles, that actually that belief or belief system that somebody says that they're now seeking to protect and influence the decision is worthy of respect in a democratic society, and is not incompatible with human dignity and doesn't conflict with fundamental rights of others. So there's a little bit of a test which we'll explore a bit further now, because that's obviously the part that recent case law has looked into in more detail, and in particular in relation to gender critical beliefs. So if we just move on to the next slide. So This is the case of Forstater and CJD, and is a decision of the EAT that essentially a minority belief can be protected, and where it's important is it goes through the Granger criteria, but also then looks at this fifth element with regard to whether it is something which can be supported and is worthy of respect in a democratic society. So just by way of a little bit of background, Mrs. Forstater held a number of gender critical beliefs in relation to immutably being female and treating identity as separate from that. She was engaged by CJD as a visiting lecturer, visiting fellow, and she had a fixed term contract. She gave voice to a certain number of her views in tweets that she posted. They were personal tweets of her on social media, but they were deemed to be offending a number of transgender people, both in terms of colleagues and more widely. And for that reason, the decision was taken by CGD not to renew Mrs. Forstater's contract. And she brought a claim challenging that on the basis that she said that the non-renewal was essentially discrimination on the basis of her philosophical belief that sex is immutable and shouldn't be conflated with gender issues, identity issues. At the tribunal level, so the first instance, she wasn't successful, and the tribunal held that essentially that her views were not those that potentially were worthy of respect in a democratic society and didn't satisfy the fifth limb of the Granger Test. And therefore, the tribunal held that her claim failed. She appealed to the EAT, and the EAT took a different approach, and essentially they overruled the tribunal and said that the belief did amount to a belief that should be protected under the discrimination legislation, and that the tribunal had erred in applying the Granger criteria. And essentially they took further counsel from the European Convention of Human Rights and a review of the wider human rights legislation, and held that a philosophical belief would only really fail to satisfy the final criteria of the Granger Test if it was the kind of belief that was akin to some form of totalitarianism, or somehow espoused violence or hatred in the gravest form. So essentially establishing quite a low threshold for somebody to say that their belief system was such that it essentially could be something that was found to be worthy of respect in a democratic society, and it's only really quite a narrow art where potentially it fails. So on that basis, Forstater was entitled to proceed with her claims, and Alice will pick up the story in relation to that in a little while in terms of the review. It's important really to see here that obviously all the EAT was doing was saying that the minority beliefs that Ms. Forstater held could be protected, and they did satisfy the Granger Test, and therefore did fall within the ambit of the Equal Rights Act, Equality Act, and that they therefore were worthy of further investigation. It was then for the tribunal to review whether she had in fact been discriminated against, and how the legislative framework applied around that. The EAT was very keen to say that it wasn't passing comment on the cogency of the views or whether they should be preferred to other views on transgender issues, but really was just trying to confine itself to looking at the case law, human rights guidance, and the extent to which the criteria was satisfied. So that's a very quick introduction to the principles about how an employer may start to look at issues of belief and understand when someone's raising an issue whether they have a level of protection under the Equality Act and discrimination legislation. Alice is now going to take those principles and take us through some recent case law, because there's been a flurry of cases reported in relation to this.
Thanks very much, Gareth. Yes, having established those principles, I'm going to have a little look at how that's panned out in some recent employment tribunal decisions. And I'm going to start off with probably one of the more straightforward ones, which involved a nurse who was employed by the Royal Veterinary College, and she was an ethical vegan, but who believed that she had a moral obligation to take action to reduce animal suffering. So she lost her job following being arrested, having undertaken some alleged burglaries as part of the Animal Liberation Front, and in fact it was found that she'd rescued a turkey and had that in her house, and she asserted that this belief of being an ethical vegan, but one who felt that breaking the law in order to prevent animal suffering was protected. The courts looked at those Granger principles that Gareth has just taken us through, and it passed a lot of them. It was genuinely held. It was a clearly strongly held belief, not just an opinion. It had some weight and substance behind it. And actually it had a level of cogency, because the Animal Liberation Front was a group of people who had held this view. However, they did find that in this instance, her belief failed on that fifth Granger principle, that actually it was incompatible with a democratic society and human dignity, because actually, although we've seen case law which supports that ethical veganism can be a protected belief, this went a step further, and in the tribunal's view, a step too far. So actually, that sort of criminal element wasn't protected because it didn't meet the threshold of that fifth criteria in Granger. So we'll look at some more difficult cases, but it's quite helpful to start with a case which shows where that line is drawn, and fairly sensible, I think. But as I said, I think this case is more straightforward than many of the others, and the cases I'm going to look at next look at what has been a particularly grey area and one of significant dispute in the media, as well as at the courts, which Gareth has been looking at, which is this view of having a gender critical belief that biological sex is an absolute, and how that interplays with those who believe in trans rights in particular. So if we can move on to the next case. This involved a doctor, Dr. McRae, who was involved in carrying out assessments, workplace assessments for the DWP over a lengthy period of time. And he's a Christian and had a view that people couldn't change their sex or their gender. And he did not believe in transgenderism or gender fluidity. At his interview, and induction training, he expressed the view that he would not use pronouns, and that he believed in using their gender-given pronouns. That conflicted with the DWP's policies of respecting transgender service users and respecting their choice of pronouns. Dr. McCareth resigned and brought a claim for discrimination on the grounds of protected belief. So the starting point was to look at whether his views were actually protected when considering these principles. The tribunal found they weren't, because they found that his views were incompatible and in conflict with the fundamental rights of the transgender community, and so therefore failed under the Granger principle. However, that got appealed up to the EAT, who did not agree with the tribunal's approach, and in a way that's very consistent with the Forstater case, which Gareth mentioned and I'm going to come on to next. Actually, the EAT found that his lack of belief in gender fluidity was absolutely protected, and that the fact that that may impact on others did not prevent it being qualified for protection. So the next element really was to say, yes, Dr. McGareth was protected under the scope of the Equality Act. So therefore, had he been discriminated against? And that was quite a different assessment. And actually, in this case, the EAT found that he hadn't been discriminated against. And there were a number of reasons for that. Most particularly because at the time he opted to resign, the DWP were carefully assessing, understanding his objections, seeing whether there were any alternatives, seeing whether there were any workarounds, and exploring how it could be resolved. So they were still at an information gathering stage. So the EAT found that he'd jumped too early, essentially. And in any event, they also looked at whether holding a view was different from the way in which you manifested that view, and actually started looking at this concept that requiring him to respect the views of transgender service users, to what extent did that impact on his own belief, and looking at proportionality there. So basically concluded that in this instance, Dr. McGareth had not been discriminated against. But it's an interesting case and does highlight some of the real challenges that we see in this area. And then that probably moves us on to the Forstater case, which is now the landmark case in this area. Gareth looked at the EAT judgment, which essentially looked at those Granger principles and established that having gender critical views, belief in gender and sex being a biological concept, was protected in law. And so it then returned to the Employment Tribunal to look at whether Ms. Forstater had been discriminated against. So Tamar, if we can just flick on to that. So the Tribunal considered this case. So Mrs. Forstater was a visiting fellow of a think tank. She has very strongly held views that about gender, and that it's a biological concept. And she engaged in considerable social media debate around this. She was a high-profile individual who was very active in expressing her views. And some of those views she expressed pretty robustly in tweets. She was critical of an award that gave an award to a transgender female, basically calling him a man, calling them a man in heels, and a cross-dresser. So very strong views, and she brought a claim that the reason her contract was brought to an end was because of that, and because other employees at the think tank had expressed their unhappiness and disquiet with the way in which she expressed her views. Well, as Gareth has explained, her right to hold those views was absolutely protected in law. And the Tribunal then looked really carefully at whether or not the reason for not renewing her contract was the way in which she expressed and the manifestation of those beliefs, and or whether or not she'd been discriminated against. And it's a really interesting judgment, which essentially says, in this instance, although she expressed those views in a way that other people may have found abhorrent or offensive, actually it didn't impact on other people's rights. And unlike Dr. McGareth, who was essentially refusing to respect transgender individuals' right to choose their own pronoun, Mrs. Forstater didn't behave in that way at all. She absolutely understood that individuals had other views and other beliefs, and she would respect those. And so she would call individuals by their acquired pronouns if they wanted that, and she would understand that they had a different view to her. She was just very active in discussing this as an issue, and the way in which she did that was pretty largely. The tribunal looked at that and said, well, actually, we do believe that people have got the right to debate these issues. And they also took into account the fact that on social media, the nature of the debate, the way in which people express themselves is perhaps very different to the way in which we might do, say, at an event like this. And so that in that context, they looked at the tweets that she'd made and found that they were not overall offensive or unreasonable. And so therefore, she was successful in her claim for direct discrimination and victimisation as well. So it's a really interesting case. I'm going to look in a second about how this might impact in practice, but it establishes that minority views can be protected, and holding those minority views and expressing them is something that needs to be permitted and is protected in the workplace. It's quite a big leap in a way to say that the way in which you're expressing your views impacts on the rights of others. But of course, there will be times when it does so, and you'll need to think as an organisation about how you might present that, or any rules that you might put in place to clearly set out your position. But taking action against somebody because you don't like their views is likely to get you into difficulties now following the forced data decision. Before we just look and reflect on some practical advice around this, we just wanted to look at another couple of cases that are going to develop these themes further, just so that you're aware of what's on the horizon. So the first we wanted to mention, again, it's only a first instance decision, but you will read about it in the press if you haven't already, because it involves a barrister and Stonewall. And Mrs. Bailey has tweeted, again, the social media interaction, and has basically challenged Stonewall, and they have had a campaign around championing transgender rights, and she sought to challenge that. And as a result, Stonewall have criticised her and accused her of being transphobic, and that led to a significant amount of trolling, I suppose, on the internet against her. And her barristers' chambers that she worked for came out really quickly and publicly made a statement that they were investigating her, which she said exacerbated matters. Her position is that it is essential in society today that you can challenge and that you can have a discussion and be constructively critical of other views. Stonewall says that that's transphobic, and Garden Court chambers are stuck perhaps somewhere in the middle. So we saw the Employment Tribunal hearing took place a couple of months ago now, and the judgment was reserved. So people are keeping an eye on that, and I'm sure it'll be in the press when it is promulgated. Another case which has been rumbling its way through the courts that we're also looking at is Higgs and Farmers School. So that's just on the next slide. And again, Mrs. Higgs is a Christian who was employed by Farmers School as a pastoral administrator and work experience manager. The school received an anonymous complaint to the head teacher about her beliefs. She'd reposted an article about the teaching in schools of same-sex relationships and marriage and gender being a matter of choice. And she said, please read this, they are brainwashing our children, and made an appeal to sign a petition. And she'd also talked about gender fluidity as being a perverted vision, and that the LGBT crowd are destroying the minds of normal children. So some really strong views, and she was dismissed as a result on the grounds of gross misconduct. Well, you will now be familiar with what the decisions are. They found that her views were protected, gender critical views protected under the Equality Act, but the Employment Tribunal found that in this case it was not her views that she was dismissed for, it was the manifestation of those and the way in which she commented on them on Facebook, and the Tribunal's view was that her Facebook posts may reasonably lead people to conclude that she was homophobic or transphobic, and actually they could negatively impact on the school and the wider community. She's now appealed that, and so that is in process, and again it will be looked at in view of the Forstater decision as well, and it will be interesting because it's another case looking along these lines and whether the expression of views on social media impacts on others sufficiently to justify the dismissal. But in another quirk to this case, which is sort of a legal point, but again shows how high profile some of these issues are, the EAT hearing, which had a panel of 3, including a judge and 2 lay members, as is normal in discrimination cases, was paused because one of the lay members asked to be recused because they are have made some very strong public statements supporting the trans community, and that they're fairly active in that area. And although actually that would not have meant that they could not consider this case in an unbiased way, the perception would be that perhaps they could not. And so they did not want this decision, which is obviously looking at very sensitive issues with very strongly held views on either side, to be criticised. So they have stepped away from the hearing. So it just shows the complexity of dealing with these issues, and the decision that the Employment Tribunal system was wrestling with is similar that you may face in the workplace too. So how can you protect your organisation, and what should you be doing about this in this very difficult area? Tamar, if we could just move on. Thanks. So some of the key messages here, respect that people may hold opposing views, and actually views that you may not agree with, that actually you may not think should be held, or that don't stand up to scrutiny when you look at the science behind it, can absolutely be protected. Those views may be views other people find offensive, but actually that doesn't stop them being protected. It also doesn't necessarily stop people expressing those views, and the expression of views does not necessarily undermine the rights of others, but it's really important that your staff understand that. And actually there, of course, like all of these things, there is a grey area in the middle, and it's important that staff understand how they can raise concerns under anti-harassment provisions if they do consider that their views are being undermined. So harassment protects people where the purpose, or more commonly in this instance, will be the effect of somebody's behaviour, creates an offensive or hostile environment that undermines their dignity. And so in that instance, if views are being expressed repeatedly or in such a way, it's possible that it could constitute harassment. So actually, if individuals do feel like that, they've got a route to raise it and for you to address those and unpick and consider how you can balance both sides appropriately. But being really careful not to limit the expression of views into robuster fashion, as otherwise you're likely to step over the wrong side of the line. It feels only recently that we refreshed our equal opportunities policy and our bullying and harassment policy, looking at sexual harassment guidance from the Equality and Human Rights Commission. But I think we're going to look at it again and think about whether you can encapsulate some of these principles so that you can help staff understand your approach as an organisation to navigating the holding and expression of different views and what is acceptable in your workplace, but being mindful that your workplace actually is not the test that the tribunals will look at. They will look at the wider societal view as a whole. I think it is helpful. More and more organisations have got equality and diversity committees, staff committees, where they're seeking views. I think it's really helpful to have some dialogue and understand a two-way communication to understand the views of staff in your organisation as well, and so that people can clearly raise issues and have them addressed. There will be occasions when you will need to come down on one side of the line. For example, the DWP, do you require that people, your staff, use the choice of pronouns, you're going to ultimately have to take a view on that. And there will be many other examples. For example, the names of toilets, the names of titles and things. So there will be times when you're forced to make a decision on one side of the line, but it's important to do so understanding the rights and views of people, and think about the proportionality involved. So it's likely that if you do that carefully, you consider any objections, you overcome those, you look at alternatives, that you will be able to defend it on the basis of having a legitimate reason and that being proportionate, so it will fall within the objective justification defence to any discrimination claim if you have got policies that potentially impede on somebody else's rights. And finally, think about social media. The farmers case is quite interesting, and lots of these cases that we've talked about, the Forstater case as well, that were where individuals were very active on social media platforms, engaged in those debates in a very public way, and that was seen to perhaps undermine their position or affect their employment. And so think about whether you include something in your social media policy to make it clear that people need to have private accounts, and perhaps include something to say that if they are going to be expressing views, it's really clear that they make it out that they're personal views, and they're not connected to them acting as a representative of your organisation as well. That brings us to an end of everything we've got to say, but if anyone wants to ask questions, please do put them in the Q&A box. Gareth, there's just one question.
Yes.
Using Forstater as an example, when does behaviour like this cross into incidents of hate? I don't know if you had a chance to reflect on that while I was talking, and so you can go.
Yes. Yeah. I think Forstater gave some commentary on this, and essentially they take guidance from the European Convention of Human Rights, and I think the threshold is pretty low. So basically, they say essentially philosophical beliefs really only fail to satisfy the final limb of the Granger Test if it's, as we talked about before, it's akin to totalitarianism, or that it somehow espouses violence and hatred in some of its gravest forms. So the fact that someone has a strongly held view, and maybe quite challenging in that view, is I imagine permitted. It's really if you would characterize what they're saying as essentially espousing a level of hatred or potentially encouraging violence, that it would then become something that obviously is not falling within the ambit of what you'd think was worthy of a democratic society in terms of freedom of expression, freedom of debate, etc. So it's relatively high threshold, I suppose. As you've talked about some of the cases that have been reported and are still going through the tribunal system, there is quite a high level of challenge. People have very strong views, but they are sitting on the right side of not actually engendering or encouraging people to violence or to hatred.
Yeah, I agree entirely with that. The next question is, how do you consider the difference between strong views or belief? Goodness, you're asking some really hard questions. And ultimately, an individual does need to demonstrate that they actively believe in something, that they're not just commenting or thinking about it. So they do have to hold a strongly held view and bring some evidence to that. I'm going to say a very lawyery answer. Ultimately, that will come down as a question of fact. The vegan cases are quite interesting when looking at that principle, because we've seen cases where an ethical vegan was protected as having a belief where that was clearly demonstrated through the whole way they conducted their lives in terms of their choice of shoes and the food that they ate and the fact that they cycled to work, and a whole range of things that showed that they genuinely held that belief. Whereas the kind of view that it's a bit better to eat meat because it's a bit healthier for you and a bit better for animals wasn't sufficient. So we've seen that division in that kind of case, and we'll probably see it in other areas as well.
Yes, I think that's right. And so in the Granger test, it's sort of the extent to which someone is holding an opinion or a viewpoint on something, and whether essentially for it to be a belief, it needs to go beyond that. So, as you say, evidence that they're living by those principles, or espousing those on a regular basis, rather than just taking a particular point or viewpoint. I think would then point towards it being a belief. That's then triggered another question. What is the threshold on someone holding a protected belief but then trying to impose that on others? And I think here it's about the fact that people can hold their beliefs, and no one belief is better than another, or is to be more protected than another. But you're then looking at how those beliefs are prosecuted, or what the impact of a decision is in the workplace, and whether it amounts to some form of discrimination. So you're then into whether there's a direct or indirect discrimination or harassment angle to what someone is doing when they're trying to encourage others to accept their belief or work go along the same lines as them. So, and again, that can be a fairly fine line. Someone can be encouraging, I think, of the fact that they have a belief system and they think others should share in that belief. But equally, if they then start to make decisions by reference to that, then that does, and someone doesn't, because again, not having the belief is similarly protected, doesn't have that belief, then in those circumstances, they potentially would have some discrimination or protection.
The next question is around policies on pronouns, and is the question is it better for it to be optional for employees rather than mandating? I suppose as a starting point, it's always better to be flexible and bring your employees along, and so allowing employees to have their choice of pronouns. But I think you probably do need to exercise care that if an individual has transitioned or strongly has a view that they want to have a particular choice of pronoun, then actually others should respect it, is really where the law is at. And so if somebody is being regularly mispronounced, they may well have protection around that, and you would need to take reasonable steps to stop that happening. So you would need to consider how that happens. So that's around an individual's choice of their personal pronoun and how they are addressed, I think should largely be protected, and people should respect that. In terms of a policy of service users, again, generally, I think the view is that individuals' choice of pronouns should be respected. And if you have employees who do not want to do that, I think understanding why not and whether there are alternatives for them and how that might be managed is the right way forward. Gareth, do you have anything to add to that?
Yeah, no, I tend to agree, Alice. I think the only other thing is obviously increasingly you see people's email sign-offs may well adopt their preferred pronoun. I think things like that probably are best left as something that's in an option for the employee, or it may well be best practice, it may well be helpful to the individuals, but really whether you adopt that or not, you may well feel that that's something that's not mandated. But it's just, it's again, the policy is about creating the appropriate culture and environment so that people can talk about those issues and can agree the extent to which they feel the need to identify a particular pronoun. I think
if there were any others, so some really interesting questions. We'll give it just a second for anybody to come up with any final points.
like we've come to the end of the questions.
Yeah.
So I think we can hand back to, oh, there's another one popped in.
Oh, there's two more. Are the government proposing any changes to legally recognise non-binary in the terms of the Gender Recognition Act? Oh, I might have to refresh my memory. There was some consultation around under the Equality Act and the protection, and the decision was to leave it as was, although there's some change of terminology in the guidance. Gareth, I can't remember any more than that.
I'm not aware of any current plans. I agree it's something which has been consulted on, but I don't think the government has then come forward and said anything particular about whether they're going to amend the Gender Recognition Act. If we're wrong on that, we will send an update to people on this call. But
we will. I don't think so. I think that's correct. I think it was consultation, and they decided to leave the status quo.
I think that's
pretty
right.
certain. And the next question is interesting. We have an employee who expressed views on her private Facebook page against the Black Lives Matter movement. They held the view that all lives matter. Again, this is something we saw a lot of, wasn't it?
Yes.
The employee had not expressed this at work, and without access to their Facebook page, the employee would not have been aware of their views. They were asked to ensure they did not express their views at work. But the employer premises had plenty of Black Lives Matter posters displayed in offices, etc. Should the employer ban such posters? I don't think banning posters is the right answer, and I think people can support those causes and promote those views. I think it's just, again, about recognising that people can hold different views and they don't necessarily impact on others. I think it, you know, again, people generally supported the cause, but not necessarily the organisation behind it, which prompted some quite interesting debates in workplaces as well. And I think as long as everybody recognises that and is able to have that discussion without doing so in an offensive way, that's okay. But I think it is a helpful thing to consider what, as a workplace, your position is around inclusivity, and make sure that's presented in a balanced way, and that if other people have views, that is very much their personal view and not and taken outside work. And the point around Facebook thinking about reminding people about privacy settings and things and how they conduct themselves is useful. Gareth, any other?
Yeah, it's interesting, isn't it, as to whether you're giving preference to one view over another if you're allowed the posters. So I suppose you may have a wider policy about how people promulgate their views and show that they identify with a particular view. And it may well be that you ask everybody to consider everyone's views, and whilst they may have posters or Facebook pages in their private lives, in their workplace, you may think it's not something that's not appropriate. I think it would have to be on a case-by-case basis, and you'd have to really think it through, because some things, such as parts of the movement around Black Lives Matter, obviously caught the public opinion, and I think people broadly agreed with the core of what was being said. But equally, there were others who didn't, and their views are equally as valid in the workplace, on the basis of not wishing to be treated any less favourably because they hold a different view. So I think it's quite I can see how it could cause a bit of tension, and it may well be you just want to give some thought as to how people express their views in the workplace.
Yeah, although I'm not sure that, I think it probably isn't the right answer to ban any such expression of views. Actually, it's about doing so in a way that is as inclusive as possible, isn't it? Really?
Yes. So if someone stuck a poster next to it saying "All lives matter," some may think that they've missed the point in terms of why it was that particular moment for Black Lives Matters. But I suppose you don't have to take a view as to whether that's a balance of views and whether that's something that's appropriate or not in the workplace, and then go through the criteria if someone is asserting protection as a result of that. Interesting questions. Really
interesting. And having training, I suppose, around these issues is useful as well, because again, that point about Black Lives Matter, that's because it was a minority group who felt that they needed to stand up and present that minority. I feel that way sometimes on International Women's Day, when at least one man says, why isn't there an International Man's Day? And so there are these points. There is now, of course, as a result. But actually, I think it's really important to recognise these points and to be able to express your view and why it's important in that way, in a way that's respectful of other views as well.
There's one final question has come in. Can we insist that employees make their social media private? I don't think you can. It's the short answer. Obviously, freedom of expression, right of expression, etc. If it's their privately held views, it may well be that they need to make it clear, if they're otherwise associated with their employer, that they are their privately held views and they don't reflect the views of others. But I don't, and you may well have a social media policy around ensuring that people don't bring an organisation to disrepute and they are mindful of what they say, which if it otherwise links them back to their workplace. But more widely than that, I don't think you can insist that social media activities are kept private.
I completely agree with that. I think you have to come at it from the other way around, saying that conduct outside of work, which may include activity on social media, it can be considered as breach of employment policies or bringing the organisation into disrepute. And so that individuals need to think about that in relation to all their behaviours outside work, including social media. I mean, they may want to think about that in relation to how they position it and their privacy settings and all of those sorts of things. So it pushes it onto the individual, and then if they do put something publicly along with where they work, then obviously there's clear case law that you can take that into account.